in this contract, there was one red flag simply too big to ignore.
Where there's a non-disparagement clause and a very, very rigorous one.
That contract clause exposed during a KSL investigation back in July, and now it's the focus of a bill on Utah's Capitol Hill. If passed, it would protect the consumer, allowing them to give their honest opinion about the buying process, both the good and the bad. News specialist Debbie Worland breaking it all down for us tonight. Hey, Debbie.
Hey, well, what we found out is the problem with these clauses is they don't allow customers to find out what companies really have their best interest in mind, because any negative opinion is silenced. Now, Tony Capone was the one that we talked to months ago. He actually backed out of a contract with the builder because they would not remove that gag clause, and he said that was a huge concern.
This clause essentially said if you said anything negative about the builder in public or in private, the damages would be liquidated damages and a voiding of the home warranty.
Now, Capone is a business and technology attorney, so when he saw that verbiage, he found it to be a huge problem. The clause says buyers can't talk, post, text, or communicate any negative information about the company in any way, whether in public or in private settings. Katie Haas is with the Division of Consumer Protection. She says the clauses are already illegal on a federal level, but this makes them illegal at a state level, which makes fighting back faster for consumers without going into litigation, which tends to be very expensive.
As a federal policy, as a state policy, we stand behind the idea that people need to be able to speak freely about their experiences with businesses.
Now, House Bill 63 would also impose fines on companies that did not remove those gag clauses. That passed unanimously today in a House committee. It goes to the House floor next, then the Senate. If it passes, it would become a law by May 1st. Back to you.
All right.